everyone. I am Evie Jeang. It's such a pleasure to talk about how to fight a domestic violence restraining order, especially everyone understand that during COVID-19, many of us had to stay home, and the data have shown that because everybody been staying home, there's a higher domestic violence incidents, and more people are filing divorce. So today we're going to talk about how to fight a domestic violence restraining order. So what is a domestic violence? For attorney that's not practicing family law, domestic violence is abuse or threat of abuse when the person's being abused, an abuser are or have been in an intimate relationship, married or domestic partner, or dating or used to date, live together, or have a child together. It's also when the abused person, abusive person are closely related by blood or by marriage. So one of the questions that I get is, since now I'm working from home, and I noticed that my neighbor have this really aggressive dog, and my neighbor being working from home also, and he's always giving me a hard time about walking past by his house and give me a dirty look and saying that if I ever cross the street again or cross by his yard, he's going to beat me up and give me a dirty look. Would that consider as a domestic violence? And I would say no. It's not going to be a domestic violence where you're going to be talking about the case, but it would be a civil harassment, which that's not what we're going to talk about today. Okay. And domestic violence laws say abuse is physically hurting or trying to hurt someone intentionally or recklessly, right? So beside what kind of relationship we consider can be a domestic violence, which we talked about earlier, a neighbor wouldn't work. And domestic violence is domestic violence is about abuse. What is abuse? Physically hurting or trying to hurt someone. It doesn't matter you have the intention or not, right? Sexual assault is another one, and making someone reasonably afraid that they or someone else about to seriously hurt them, like a threat or promise to harm someone. Or behavior like harassing, stalking, that's another one, threatening, or hitting someone, disturbing someone's peace, or destroying someone's personal property. Okay, I just want to add this, which you're going to see on the bottom, the physical abuse, not just hitting. Abuse can be kicking, shoving, pushing, pulling hair, throwing things, scaring, following you, or keeping you from free coming and going, and can even include physical abuse of the family pet. I have a recent case which the girlfriend is accused of client that abusing their puppy, this really adorable, cute puppy with a scrunchy face. So domestic violence doesn't have to be just with the person. It can also be a physical abuse of the family pet, which is really sad. And whether it's true or not, no one should do that. Okay, so we just want to go to what is domestic violence, what kind of relationship can be considered domestic violence, and what kind of action would be considered as abuse. Does the intention matter? And again, domestic violence can be also sexual assault. And what's the standard? Someone reasonably afraid of somebody in a reasonable person standard, right? And physical abuse, again, doesn't have to be the person. It can also be physical abuse of the family pet. Okay, let's go on the next slide. What is the California Code for domestic violence? If you need to look at the legal definition of it or the law, domestic violence section on the family law, California Family Code, is 6203. And also domestic violence, when you file a TRO, a lot of time there's a criminal charge against the abuser also. So on the criminal domestic violence law, California Penal Code, sections 273.5, Penal Code section 243, E1 and other. Okay, but today we're going to talk about the family part of it. In the family court, what happened when someone filed a restraining order because accusation or a real case of domestic violence. Okay, let's go on to the next one. Possible effects of a restraining order on the restrained person. For the person to be restrained, the consequences of having a court order against him or her can be severe. What would happen, right? What would be the result if someone have a restraining order against them? He or she would not be able to go to certain places or do certain things. A very common one would be when someone filed a restraining order, if the court granted, he or she would have to stay away from the person 100 yards. That's the very standard one that we see. He or she would also, the accuser, not the accuser, the person's being accused, he or she would not be able to go to certain places or do certain things. He or she might have to move out of his home or her home, and also affecting their ability to see their children if they have children together. Like I said earlier, the relationship or intimate relationship, they used to date it or not, and have children together. Okay, and also if he or she have gun at home or in possession of a gun, he or she will have to turn it in, sell or store any firearm that he has, right? Because he or she would not be able to buy a gun while the restraining order is in effect, because we wanted to make sure that the person's accused the person being violent is protected. The restraining order may also affect her immigration status. If you are worried about this, please do talk to an immigration lawyer to find out if you would be affected. This is the reason when someone gets accused of domestic violence and they file a restraining order, it's very important to ask your client or ask if it's not going to affecting the immigration status, what immigration status they're in. And again, if your clients have some problem with the immigration status, always advise them to talk to their immigration lawyer, because having a restraining order against them might affect their immigration status, especially if they're not a U.S. citizen, they're a permanent resident, or even here on the conditional basis. Having a restraining order on them or against them is not going to be helpful. Okay. What are the additional effects the restraining order can have on the party, restrain the party, right? A domestic violence restraining order is a court order that helps protecting people from abuse or threat of abuse. It can order you to no contact and go to certain places or go near the protecting person. Those are the lists. I'm going to leave it on this slide. I'm not going to go do one by one because we did mention most of the important one. Also, phone call, you can call them or start texting them about whatever the question is. One scenario that I see a lot for our client, because we handle family law cases, is that they have children together. And then when somebody files a restraining order against our client, then he or she cannot talk to their children, and a lot of time, or you have a specific way of talk to the children, but it cannot be anything a threat to the parents or the person that filed the restraining order. So the conversation just has to be stick on the children, discussion of the children only. So that's a little bit more deeper than the basic effect having order against you. So I'm not going to go through the list. You can take a look. I'm going to leave it right here for a few minutes, and I'm sure we can get a copy of that online. But take a quick look before I go on the next page. Oh, and sometimes having domestic violence order against you also require you to take anger management classes, and cell phone number had to be turned over, and those are the lists. Okay. And then we can go on to the next one. Type of domestic violence restraining order. Emergency Protecting Order, EPO. There are a couple. I'm going to go with the most shorter one. Emergency Protecting Order is the shortest one compared to Temporary Restraining Order and Permanent Restraining Order. And another one is Criminal Protecting Order, which that's not something we deal with, but we're going to mention that because that's type of domestic violence restraining order. EPO, Emergency Protecting Order, is something that is emergency, where you can call the local or go to the local police station and have them to ask the judge to issue one. It's the shortest one because it only lasts 7 at most. The judge 24-hour. This is literally emergency. So you don't have to wait till the next day when the court opened. You literally can call the judge, and the judge can issue one if the judge felt that you need an EPO to be safe from the person who's being abusive. The next one is temporary restraining order. Temporary restraining order is that you would have to go to court, ask for domestic violence restraining order, you fill the paperwork, and you have to tell the judge everything, what happened to you, and why you need a restraining order. If the judge believes that you need protection, he or she will give you a temporary restraining order, and the temporary restraining order lasts longer than EPO, and is about 20 to 25 days until the court hearing day. Okay, so this is a little side note because we are now dealing with COVID-19 when all the court are closed. However, the court were open for emergency hearing. What considered being emergency hearing? Well, guess what? In family law, emergency hearing would be domestic violence when one requests for restraining order. So restraining order is one of those emergency hearings that you can be or brought to the court, even during COVID-19. Okay, so after temporary restraining order, which lasts about 20 to 25 days, the next one is a permanent restraining order. When you go to court for the hearing that was scheduled for your TRO, the judge may issue a permanent restraining order. They are not really permanent, even though they say permanent. It's not forever rest of your life, but it's permanent restraining order because they usually last up to 5 years. The typical is about 3 years, but they can last up to 5 years. By the end of the 5 years, you can always ask for renewal or new restraining order so that you can be protected still if it's needed. Finally, we're going to talk about the criminal protecting order or stay away order. Sometimes when there's a domestic violence incident or just many incidents, serious incidents, the district attorney will file criminal charges against the abuser. This starts a criminal court case going. It's common for the criminal court to issue a criminal protecting order against the defendant, the person who's committing violence and abuse while the criminal case is going on. And if the defendant is found guilty or plead guilty for 3 years after this is over. So again, we don't deal with the criminal law today. We deal with the family law. But one of the advice which we're going to talk about later on is if this is a criminal hearing or a case being brought up by the district attorney, as the family law attorney, I would always ask the judge to continue till the criminal hearing is done. The reason is I don't want to go family court, restraining order hearing, and have my client to testify for anything that might used against him or her in the criminal proceeding. So this is just a side note, which we can talk about that in the later slide. But since now we talk about different type of domestic violence restraining order, and we happen to touch a little bit on the criminal part of it, this is just a little suggestion or tip for family law practice or when you come across dealing with family law cases. And another thing I wanted to say is that if the DA decided to bring a criminal charge against your client, domestic violence, it's not up to the partner or the ex-girlfriend, ex-spouse to say, we made up, it's fine, I want to drop a case now. Unlike family law, all the time it was a one-night argument, people losing emotions, especially with COVID-19, people getting antsy, stressed, and it was over the next day. And then now the party decide to make up or decide to get back together or they talk it out. But with criminal protecting order or when the DA decided to bring a criminal charge against the abuser, even the partners say, you know what, there was a bad day. We both were very upset, but I'm over it. I don't want my partner or the father or the mother of my child having this restraining order against them. It's too late. It's not up to the partner. It is the DA that have the control to file the claim, file the charges or not. So they have nothing to do with a partner or ex-partner. Okay, I just wanted to give you a little knowledge on that, the tip on that. Okay, take a look, and then so we can move on to the next slide. And go on the next one. So what are the order that can be, right? And then it's very important when your client have a TRO against them, what should you tell your client, right? For example, those are the stuff advise client of any stay away or no contact order immediately. A lot of times they have no idea. And then your client might say, well, I need to pick up something from her, or I need to go back to my house to pick up my clothes, or whatever the excuse is. A lot of time our client call us and say, hey, there's a restraining order, but I'm just going to call her or call him to arrange child pickup tomorrow, or I'm just going to stop by, pick up my toothbrush. No. When there's a stay away, no contact order, it means literally stay away and no contact. Do not text, do not call, right? Also move out order. You need to move out. And also property control order, which a lot of time you cannot refinance your house, which even with COVID-19, a lot of people want to refinance their house. If there's some cash out, no, you can't do that. You can't make any major decision while there's a TRO against you. And you also need to, or you might be ordered to pay for spouse's support while you're moving out of the house. Because what about the bill? What about the mortgage? Who's going to pay for that while there's an order against you? So if your excuse is saying that, well, I need to go home and pick up the bill, I have to pay for the bill. It says, I've been moving out, I don't have to pay for anything or support my family. No. A lot of time with just a restraining order, temporary restraining order, the court would sometimes order a temporary spousal support so that your spouse or soon-to-be ex-spouse or ex-spouse would still be okay. And that also has to do with child support if you can have children together. And since we talk about that, we're going to talk about marital property transfer. At this time, if you got married, you cannot assign your property or house to your mom or to your sister or brother. Pretty much everything stopped. You cannot make any transfer of the marital property, okay? Also, that apply to debt. Credit card, go crazy with your credit card. Oh yeah, she kicked me out or she made me move out. Now I don't have money. I'm going to put debt on it and it's going to be our community debt. No, you can't do that. And as I mentioned earlier before, if you own a gun, firearm, you would need to turn them in to the local police station, surrender them, okay? So those are the order. When you get those, you need to advise your client and be aware of. And I'm going to leave it for a little bit. So take a quick look before I move on to the next slide. And let's go. Okay, so when your client come to you and say, hey, I have no idea this, I just got served with this restraining order, do I need to file a response or what I need to do, right? A lot of time, I notice when someone get a restraining order, they were very confused a lot of time because there might be just a normal argument or they have no idea what's coming. And sometimes they get scared because now there's a restraining order, what's that mean? And then all I know is that I would need to go to court in the next month, what's going on, okay? So all the time when my client come into me and tell me about this, I said, be calm, let's take care of it, let me see what happened, why your partner, ex-partner, wanted to file a restraining order against you. So I will look at their petition, their declaration, and find out what happened to the story. A lot of time you wanted to make sure you get the full story because the client come to you, don't always tell you the whole story. And then I would tell them that, okay, we will file the response, but not right away. The reason is I wanted to first find out if my client's telling me the truth. And you guys all know how much the story are twisted a lot of times from the clients, right? They never tell you the full story. And then I will look at the petition and see what are they saying. Oh, that makes sense. I wanted to verify with my client, right? And then I'm going to see, well, by the time, which just happened to me a lot, and I'm pretty sure this happened to you, all of you a lot. Client doesn't come to you till the very end, which will leave you really no time or very little time to be prepared for the hearing. So most of the time when my client come, the hearing will be in 2 days or that same week. And then the petition, what the declaration be saying, is like page long. There's so many numerous text, photo, all that. So I need to see if I need time to continue, right? So then I can be more prepared, at least respond to the accusation, every statement or everything that they accuse my client of. So I have to start thinking about creating a discovery plan, right? And hold on, let me go to the graph. Sorry about that. Okay, so then I had to think about how am I going to defend my client? What would be my strategy, right? And so do I need witness? Should I asking for what's going on? Maybe the reason why they filed this restraining order because the person's also filing a divorce and they want to take advantage of this by kicking my client out first. I don't know. So those are the stuff that I need time to think about and decide if I need to file a response to every accusation. And I need sometime, I wanted to see the picture. Sometimes I want to listen to the voicemail message. Sometimes I wanted to ask my client, is this a witness there? Maybe I need to talk to the witness, right? So those are the stuff that I kind of wanted to decide what I need to do. So before you file the response or anything like that, I wanted to go through all this question before I make my mind. Another thing is when you go to court, when you ask for continuance, I think it's more likely. First of all, you have the right to continue once. And number two, by saying this, what was going through my mind, I think the judge would allow me to continue for my clients so then I can be more prepared to file the response. And also, I want to find out if there's a criminal charge against my client also. Like I said earlier, if this is a criminal charge that is being filed, I would definitely want to continue and not file the response because I want to make sure everything's okay in the criminal part before I make any admission or hurt my client's cases in the criminal side. If I file something in the family side first and they can use it against my client in the criminal side. Okay, so let me go on the next slide. And like I said, we have the right to continue a DVTR hearing. Ex parte temporary restraining order, right to one continuance of family code section 245. I'm not going to read out this session because I'm just going to leave it there. You can, when you have time, take a look. But then you always have the right to one continuance. And then, like I said earlier, not filing a response because you got the case at the last minute. You need some time to address everything. Makes sense to also to continue. And that's not a reason why I wouldn't file the response right away. I would think about my strategy first if that's necessary. Okay, so this is the family code section 245. It just pretty much give you the co-session as your right, your client's right to continue a DVTRO hearing. And let's move on to the next one. And again, why I want to continue the hearing, I bring back to what I said earlier, prepare, right? Because on the petition, I will see what they're saying. Do I need to come up with exhibit? Do I need a witness? Do I need to subpoena anything? Video surveillance. We have another client that a nice gentleman, the girlfriend accused of him pushing her and beating her when my client got in a fight because my client caught her having an affair with another man, and there's a video camera. So we were very lucky because it was video camera at the house. We filmed that the accusation, the statement that the girlfriend was making against my client was not true. My client was holding the baby, was trying to walk away from her while she was screaming out client. And without having this video footage to show that, it wouldn't help us on our case because the girl was like really tiny and small. My client was actually really 6'2", 6'3" big guy. So it was nice that we had that video footage to show that it was a false accusation. And this is the reason before we go forward, we wanted to make sure we have all the evidence, witness, and if we had to subpoena a third party, we would need time to do so. Sometimes they're saying the argument was at the gas station. So I would like to know if there's anybody seeing there was a fight going on. So, okay. Next slide. Legal strategy. One thing is, if there was really a violent accusation, or even it's true, I always ask for a police report because when there was a domestic violence going on, the one party would call, and then if the police show up, they should have a police report or incident number. So I would ask my client, is there a police report? I can read it. And then what was the police finding or observation or interview, right? And sometimes if the police find there was no case, you can at least get an incident number. So at least that would help you. And I will also look and ask my client if he or she ever had a prior domestic violence restraining order from different partner or from the same partner. And I will also see if the accuser have any domestic violence order in the past. I will also look at the court docket for the client because, like I said, you just don't get the complete truth. Not that your client wanted to lie to you, but sometimes they see things in their way and didn't think that was relevant, or they really don't think their action is a domestic violence, right? So not saying that you don't give your client full credit, but you need to get the full truth. You really need to get the whole story. And sometimes you wanted to take a deposition of petitioner or respondent, your client, or other witness before the domestic violence restraining order hearing. Sorry. So one of the things we do is that we sometimes would ask the nanny, because a lot of time if they have children together, there's nanny that living at home, or the babysitter to see if there was ever a domestic violence incident that happened. Sometimes a lot is the neighbor. Do they hear them screaming? School, the teacher. A lot of those can be ask or write a declaration with deposition, whatever you think would best fit your case. And also you wanted to make sure all the favorable deposition transcript are lodged into court record before the trial, right? So then the judge can also see that before the hearing. And we go on the next one.